what every retiree needs to know about Medicaid, long-term care, and protecting family assets. Most Americans believe that after decades of working, paying taxes, raising families, and contributing to society, the healthcare system will protect them in retirement. But many families discover too late that long-term care in the United States works very differently than they expected. A stroke, a dementia diagnosis, or a severe illness can create costs that quickly drain retirement savings. Nursing home care can exceed $10,000 per month in many parts of the country, and the rules surrounding Medicaid eligibility, asset protection, and estate recovery are widely misunderstood. This is not about alarm or speculation. It is about understanding how the system actually works so families can make informed decisions before a crisis occurs. The goal here is education, helping retirees and their families better understand long-term care planning, Medicaid rules, common misconceptions, and why timing matters when it comes to protecting assets legally and responsibly. The reality of long-term care costs. Long-term care is one of the largest financial risks facing retirees today. Many people spend years preparing for retirement income, investment management, and Social Security strategies, but far fewer prepare for the possibility of needing assistance with daily living activities later in life. Those activities can include bathing, dressing, eating, mobility assistance, medication supervision, memory care, and around-the-clock monitoring. When someone requires ongoing custodial care, the costs can become substantial. In many states in 2026, assisted living facilities may cost $4,000 to $8,000 monthly. Skilled nursing facilities may cost $9,000 to $15,000 monthly. Memory care units may exceed $15,000 monthly in some metropolitan areas. A multi-year stay can easily consume hundreds of thousands of dollars. That financial reality often shocks families because many assume Medicare will cover these services indefinitely. In most cases, it does not. Medicare versus Medicaid. The confusion that hurts families. One of the most widespread misunderstandings in retirement planning is the difference between Medicare and Medicaid. The names sound similar, but the programs operate very differently. Medicare is primarily health insurance for people aged 65 and older. It generally helps cover hospital care, doctor visits, surgeries, rehabilitation, prescription medications, and limited skilled nursing care following a hospitalization. However, Medicare does not generally pay for long-term custodial nursing home care on an indefinite basis. Medicare may temporarily cover rehabilitation services after a qualifying hospital stay, but that coverage is time-limited and depends on whether the patient is actively improving. Once someone primarily needs help with daily living activities rather than active medical rehabilitation, Medicare coverage typically ends. This is the moment many families begin facing serious financial pressure. Medicaid is a separate program jointly administered by federal and state governments. Unlike Medicare, Medicaid can cover long-term nursing home care for eligible individuals. But Medicaid is means-tested, meaning applicants must meet financial eligibility requirements involving income and assets. That creates a significant challenge for middle-class retirees who may own a home, hold savings accounts, or have retirement investments, but realistically cannot afford years of nursing home costs out of pocket. Why families feel caught off guard. A common situation unfolds like this. Situation. A parent experiences a stroke, rapid cognitive decline, Parkinson's progression, or dementia complications. The family suddenly faces urgent care decisions. At the same time, they discover that Medicare coverage is limited, long-term care insurance may not exist, nursing home costs are substantial, Medicaid eligibility rules are complex, and asset transfers can create penalties. All of this happens during some of the most emotionally overwhelming circumstances a family can face. People are trying to make healthcare decisions while simultaneously navigating legal and financial systems they never fully understood before. Understanding the Medicaid look-back period. One of the most important concepts in Medicaid planning is the look-back period. Most states apply a 5-year look back window when reviewing Medicaid long term care applications. This means Medicaid agencies examine financial transactions made during the prior 60 months before the application date. The purpose is to prevent people from simply transferring assets immediately before applying for Medicaid. During the review, states may examine bank transfers, property transfers, gifts to family members, large withdrawals, asset sales below fair market value, and changes in ownership structure. If disqualifying transfers are identified within the look-back period, a penalty period may be imposed that delays Medicaid eligibility based on state-specific formulas. This is one of the primary reasons why timing matters significantly in elder law planning. Common mistakes families make. Many families unintentionally create problems because they receive incomplete or oversimplified advice. Some of the more common mistakes include adding children to property deeds, believing this automatically protects the home. In reality, this approach can create Medicaid transfer penalties, tax complications, creditor exposure, divorce-related risks, and probate complications. Another frequent mistake involves large gifts made during retirement, such as helping grandchildren with tuition or home purchases. Generous gifts made within the look-back period can potentially affect Medicaid eligibility calculations later. Perhaps the most costly mistake of all is simply waiting too long. Many families only begin researching Medicaid rules after a health emergency has already occurred. At that point, planning options may be considerably more limited because the look-back clock cannot be reversed. Medicaid estate recovery. Another area many retirees do not fully understand is Medicaid estate recovery. Federal law generally requires states to seek reimbursement for certain Medicaid expenditures after a recipient passes away. This process is called the Medicaid Estate Recovery Program, or MERP. States may attempt to recover from assets remaining in the deceased recipient's estate, depending on how assets were structured and the laws of that specific state. Recovery rules vary significantly across the country. Some states pursue recovery aggressively, others are more limited in scope. Some states focus primarily on probate estates, while others may apply broader recovery rules. This variation is one of the key reasons state-specific legal guidance is essential. Why state laws matter so much. Long-term care planning is heavily shaped by state law. Two families with identical financial situations may face very different outcomes depending simply on where they live. Medicaid asset limits differ by state. Estate recovery procedures differ by state. Home equity protections differ by state. Trust treatment differs by state. Spousal protections differ by state. Because of this, general advice found online can sometimes create serious problems if applied without accounting for the specific laws of the state where someone resides. Proper planning must always be tailored to the individual state. The role of Senior Support USA and elder law attorneys. This is where qualified elder law attorneys become especially valuable. Senior Support USA connects families with elder law professionals who focus specifically on Medicaid planning, long-term care planning, asset protection strategies, estate planning, guardianship, powers of attorney, and trust structures. These professionals help families understand legal options before crises occur. Legal planning must also be done correctly, because poorly drafted documents or improper transfers can produce unintended consequences that are difficult or impossible to reverse. Medicaid Asset Protection Trusts. One planning strategy some families explore is a Medicaid Asset Protection Trust, commonly called a MAPT. A MAPT is generally an irrevocable trust designed to help protect certain assets from future Medicaid spend-down requirements if implemented properly and with sufficient lead time. Key concepts typically include the irrevocable structure of the trust, independent trustee management, strict timing requirements, look-back compliance, and limitations on retained control. However, MAPTs are highly technical legal instruments and are not appropriate for every situation. They involve real trade-offs and restrictions. Assets placed into the trust may no longer be directly controlled by the original owner. incorrect drafting can cause the strategy to fail entirely. Tax implications must be carefully evaluated, and state-specific rules always apply. This is precisely why working with a qualified attorney matters. The importance of planning early. One of the most consistent lessons families learn is that planning opportunities are greatest before health begins to decline. When someone is healthy and legally competent, they generally have more options available. Once a major medical event occurs, choices often narrow considerably. That does not mean families are powerless during a crisis, but proactive planning almost always provides greater flexibility. Even foundational steps can make a meaningful difference, including updated wills, durable powers of attorney, healthcare directives, proper beneficiary designations, long-term care conversations with family, asset inventories, and a basic understanding of state Medicaid rules. The emotional side of long-term care planning. Long-term care planning is not only a financial matter, it is deeply personal. Adult children often struggle with guilt, family disagreements, caregiving exhaustion, financial anxiety, and the pressure of time. Parents may fear losing independence, becoming a burden, losing their home, or running out of money. These emotions can lead to delayed decisions or avoidance altogether, but avoiding the conversation rarely leads to a better outcome. Families who discuss these issues earlier tend to navigate crises more effectively when they eventually arrive. Why financial education matters. Many retirees spend decades learning how to earn and accumulate money, but very little time learning how late-life healthcare systems actually function. That gap in understanding creates real vulnerability. People may assume Medicare covers nursing homes indefinitely, that their home is automatically protected, that small gifts never matter, or that all states follow the same rules. Those assumptions are often inaccurate or incomplete. Better education allows families to ask better questions, plan earlier, avoid costly mistakes, understand trade-offs, and reduce panic when emergencies arise. Questions every retiree should consider. Regardless of income or asset level, retirees should consider thinking through several important questions. What would happen financially if I needed nursing home care for several years? Do I clearly understand the difference between Medicare and Medicaid? Do I have updated legal documents in place? Has my family had an honest conversation about long-term care preferences? Have I spoken with an elder law attorney familiar with the laws in my state? Would long-term care insurance still make sense for my situation? Do I understand how my state handles estate recovery? Are my current asset ownership structures appropriate given my circumstances? These conversations can feel uncomfortable, but avoiding them does not reduce the underlying risk. The bigger picture. The American long-term care system is genuinely complex. It combines healthcare policy, tax law, state regulations, estate law, insurance systems, and family caregiving realities into something that very few people fully understand before they are forced to engage with it. There are no perfect solutions. Every planning strategy involves trade-offs between control, flexibility, tax treatment, asset protection, simplicity, and cost. The goal is not anxiety, the goal is awareness. Families who understand how the system works earlier are generally in a better position than families who are learning everything for the first time during a medical emergency. Most retirees are not trying to work around the system. They simply want to protect a spouse, preserve their dignity, avoid unnecessary financial hardship, leave something for their children, and maintain meaningful choices later in life. Understanding Medicaid planning, estate recovery, and long-term care rules has become an essential part of modern retirement preparation. But every family situation is different. The right approach for one household may be entirely wrong for another, depending on health status, financial picture, family dynamics, state law, risk tolerance, and long-term goals. That is why education matters and why working with qualified professionals matters even more. The earlier families begin engaging with these issues, the more options they typically have available. And in many cases, understanding the rules before a crisis occurs can make an enormous difference, emotionally, financially, and practically for everyone involved. This content is for educational and informational purposes only and should not be considered legal, tax, investment, or financial advice. Medicaid laws vary by state and change over time. Always consult a qualified elder law attorney or licensed professional regarding your specific situation.